Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to another episode of our Curious Amalgam. I am Sergei Zaslavsky, and the title of today's episode is Has the Risk of Information Exchanges Shifted? DOJ's Withdrawal of Healthcare Policy Statements. It's no secret that the antitrust agencies are trying to usher in an era of more aggressive antitrust enforcement. A lot of airtime is devoted to big philosophical questions relating to changes in antitrust enforcement, such as what the goals of antitrust should be. But the more aggressive approach has very practical consequences as well. And today we're talking about one of these practical topics, DOJ's policy toward information exchanges between competitors. For 30 years, companies in healthcare and other industries have relied on agency guidance setting out safe harbors for certain kinds of information exchanges. On February 3rd, DOJ said this guidance was outdated and overly permissive, and withdrew a series of policy statements containing the safe harbors. Joining me today to explore this important development is Jaclyn Phillips. Hi, Jaclyn.
Hey, Sergei.
Jaclyn, why don't you introduce our guest and kick off the discussion?
Leslie Overton is here today, and Leslie is a partner at Axinn, where she also serves as the firm's Chief Diversity, Equity, and Inclusion Officer. At Axinn, Leslie works on merger reviews, civil and criminal antitrust investigations, litigation involving antitrust authorities, and counseling. Before Axinn, Leslie previously served in senior positions at the Department of Justice Antitrust Division, including as Deputy Assistant General for Civil Enforcement during the Obama administration and counsel to the Assistant Attorney General during the Bush administration. Thanks for being here, Leslie.
Great to be here. Thank you all for having me.
To get the conversation started, can you give us an overview of the policy statements that the Department of Justice withdrew on February 3rd, 2023?
I am happy to do that. As Sergei said, these were three policy statements that DOJ deems outdated and overly permissive. And so these are all from the healthcare arena. The first is the DOJ and FTC antitrust enforcement policy statements in the healthcare area, and that's from 1993. The second is the statements of antitrust enforcement policy in healthcare from 1996. And then the third is the statement of antitrust enforcement policy regarding accountable care organizations participating in the Medicare Shared Savings Program, and that's from 2011. And I just note, these are not policies that were issued during Republican administrations. These came out during the Clinton and Obama administrations. And I'll also note that, at least as of the time that we're all here talking, a lot of folks expect the Federal Trade Commission to, at some point, follow suit and withdraw this guidance themselves. The healthcare guidance covers various types of collaborations among healthcare providers to bring down costs. That could be through joint ventures, group purchasing arrangements, or information exchanges, for example. The 2011 statement relates to provider collaboration to provide integrated health care through accountable care organizations consistent with the Affordable Care Act. The guidance we're talking about contains safe harbors or safety zones so that providers and their counsel can engage confidently in potentially pro-competitive activity due to an understanding that the antitrust agencies would not challenge it, quote, absent extraordinary circumstances. We're going to be focusing our time together, I think as Sergei previewed, on the information exchange guidance. That is what DOJ has talked about the most and likely where the withdrawal of the guidance will have the broadest impact. I just want people listening to be aware, however, that other portions of the guidance withdrawal have ramifications for folks in the healthcare industry. If your client is engaged in group purchasing or other activity based on a safe harbor, have antitrust counsel take a look to assess the risk. And for reasons that we're going to talk about, it is also definitely worth revisiting the information exchanges that an organization engages in as well. Don't assume that any benchmarking or similar exercises that a client is engaging in have a level of risk that the client would deem acceptable now that the safe harbor is gone.
Well, and let's dive into the information exchanges. To help out some of the listeners that may be newer to antitrust, what's the antitrust risk with information exchange? If you're not actually agreeing to fixed price, what's wrong with exchanging information?
Well, thank you for that question. So I'm going to refer to DOJ's Principal Deputy Assistant Attorney General, Doha Meki. As she stated in a speech last month that preceded the guidance withdrawal, she said, she pointed out there can be a couple of types of unlawful information exchanges. First, she pointed to per se unlawful, that is, information exchanges condemned on their face if they're a method for facilitating price fixing or market allocation, bid rigging, or similar conduct. And second, information exchanges, there can be one that isn't automatically condemned, but is unlawful under a rule of reason analysis or a holistic analysis that assesses whether the harm outweighs the pro-competitive benefits if the exchange leads to an anti-competitive effect in light of things like the nature of what was exchanged and the industry structure. And I'll also just point out that information exchanges can frequently factor into private lawsuits as plaintiffs' lawyers claim they are evidence of a conspiracy. And so it has long been important for parties interested in benchmarking activities or other information exchanges to proceed carefully. Now they're going to have to be that much more careful in the absence of the safe harbor.
Thanks, Leslie. So it looks like, before and especially after the withdrawal of these guidelines, there's some serious, risk analysis that has to be taken into account if exchanging, certain types of sensitive information. You mentioned, just talking about the titles of these guidelines, that they're relevant to the healthcare industry. So is this policy announcement relevant to just healthcare companies, or is it relevant more broadly? And what industries relied on these safe harbors?
So there are parts of the guidance that are going to be relevant to the healthcare industry. If they're focused on some parts that could be more relevant to if they're focused on participating in an accountable care organization, for example. And so that is healthcare specific. But the information exchange portion of the withdrawn guidance in particular is relevant far beyond healthcare. So trade associations and other groups in many, many industries relied upon the safe harbor, particularly with respect to benchmarking activity. A company might want to confirm that it is competitive with respect to wages and salaries, for example. And so I can't give you a list of industries because it's so broad. And so if you were participating in a benchmarking exercise, the best practice was to rely on the safe harbor. That doesn't mean that something outside of the safe harbor was necessarily unlawful, but the safe harbor was a way that companies, trade associations, other organizations could get a degree of comfort in a cost-effective way. And so this has the information exchange part in particular has just broad ramifications beyond healthcare, which I am confident DOJ knows and intends. And I should say DOJ, again, just going back to Principal Deputy Mekhi, and I would recommend her speech from February to everyone listening. One of the things that she pointed out is just a perception by DOJ that the safe harbor had been used more broadly in industries that maybe hadn't been envisioned at the time, and so confirming their recognition that it's used broadly. Although I will say some of the other points that she made in her speech suggest that they wouldn't necessarily think that it would be fine if it were just limited to healthcare, because they've seen a lot of changes in the healthcare space that they think are relevant since the time of these guidelines.
So we're starting to talk about why DOJ withdrew the safe harbors. Before we get there, though, let's define for our listeners what the actual safe harbors were. What information exchanges were covered by these safe harbors?
Sure. So here are the criteria that DOJ views as outdated and overly permissive. The collection of the competitively sensitive information is managed by a third party. The data is older than 3 months. The data are anonymized and aggregated, and there are at least 5 participants, with no single one constituting more than 25% of the input for a statistic. So I'll go through in just a little bit more detail the different criteria. With respect to collection by a third party, DOJ is they're skeptical that makes a difference. They believe they've seen situations that they characterize as anti-competitive information exchanges where there was a third party doing the collecting. As for the age of the information, I think there are a couple of points. First, I think DOJ just wants to be fact specific in its approach to these information exchanges, which I'm sure I will come back to during our conversation, because I think it's an important point. And so what if DOJ doesn't think 3 months is long enough for certain type of data to become stale? They may see it as depending on the facts. What's the relevant bid cycle or the compensation adjustment cycle, and so they might not even agree that older than 3 months is stale in a particular circumstance. And second, they pointed out that even if data is stale, they don't think that's necessarily enough to prevent anti-competitive use. And so going back to Principal Deputy Mekhi again, she indicated that the realities of machine learning and algorithms could impact the degree to which even aggregated stale data could be used to get information about a competitor's strategy in some industries. And then I'll just say, finally, with respect to the number of participants, Principal Deputy Mekhi noted DOJ has seen situations where there are information exchanges they deem anti-competitive that are not characterized by a small number of players. She referenced a recent consent decree whose complaint alleged at least 15 firms participated in the alleged information exchange conduct. So I think they're pushing back here on the idea some may have that this concern about information exchange is limited to oligopolistic markets.
Thanks, Leslie. And you already alluded to this in describing each of these factors, but how big a role did the specific factors that were in the guidelines play in DOJ's analysis in, bringing cases and then withdrawing the guidelines, and how significant is this policy change?
So in terms of how big a role the factors played up to this point, just in terms of their enforcement policy, I can't speak to any non-public matter while I was there, but I can say that when I was at DOJ, we relied upon the healthcare guidance in the business review context, as did our predecessors, as did our successor. Business review letters are letters that lay out the division's likely enforcement intentions with respect to potential conduct that parties are considering, but they're not actually doing. They want to just kind of get a like an advisory opinion based on the facts that they provide to DOJ. They want to get some sense as to what DOJ's anticipated enforcement intentions would be based on such facts. I will point out that the guidance for human resources professionals that DOJ and the Federal Trade Commission issued in 2016, near the end of the Obama administration, explicitly relies on the information exchange safe harbor with respect to labor markets. And in fact, the fact sheet for President Biden's executive order on promoting competition in the American economy from 2021 specifically references that reliance, and not in a positive light. It says, quote, "Workers may also be harmed by existing guidance provided by the Department of Justice and Federal Trade Commission to human resource personnel that allows third parties to make wage data available to employers and not to workers in certain circumstances without triggering antitrust scrutiny. This may be used to collaborate to suppress wages and benefits," end quote. And there is a good amount of benchmarking activity out there that relates to wages and salaries, and so and the executive order was looking at it in a different light, rather than looking at it as, well, this is an opportunity for organizations, for a trade association and the companies in it to make sure they're being competitive in the marketplace. The Biden executive order was looking at it more as, well, this is a way that they can have wage information that the workers don't have and that they could use to keep wages down.
Super interesting context, and really exemplifies the complexity of this and really how major this policy decision is, and how many different things it impacts, and sort of bringing this all together in another sense. Information exchanges, that conduct is well developed in antitrust case law, and the DOJ announcement doesn't change what the law is in that sense. So what would you say as to how the policy announcement changes how companies should view the developed case law on information exchanges?
So that's an excellent point that you make. It is not changing the law, but it is paving the way for DOJ, should they choose, to try to push the law in a particular direction. And so the safe harbor was about what is the enforcement policy. When will DOJ be concerned, and them telegraphing that in advance? If you're checking these boxes, if you're meeting these criteria, you can have a level of confidence that, absent extraordinary circumstances, your information exchange is not going to to get challenged. And so, but now with that gone, that frees the way for DOJ to have a different level of freedom to challenge information exchanges that might meet those safe harbor criteria, but that DOJ still deems are harmful to competition. And so, it is. I think it just, like I said, it gives them an opportunity to move the law, but it also gives them an opportunity to it also gives them an opportunity to have an impact on the proliferation of information exchanges. And so, because there is now this level of uncertainty, I don't know whether DOJ would necessarily think that my information exchange is one that they would want to challenge. And so now maybe I'm not going to engage in that information exchange, even if I think it's a pro-competitive exercise. And so I may not have the appetite for that risk. Now there are certainly antitrust counsel can analyze situations and give guidance and help people to understand what is more likely to get challenged than something else. But there's just still a level of uncertainty, a different degree of uncertainty than what was there before this withdrawal.
Certainly, DOJ can affect conduct, even if it's not reflected in black letter law, just given different companies' appetite for risk.
Absolutely.
One of the things that I find really interesting about this policy change is that it was prompted, at least in part, by technological change. As you said, DOJ used to think that exchanges of stale data that was aggregated probably were not going to be that competitively sensitive. But now, with the development of algorithms and machine learning, DOJ is concerned it may be easier for companies to derive competitively sensitive insights from that stale aggregated data. Do you think there are other DOJ or FTC policies that may change in light of the rapid technological advancements that we are seeing?
Well, I think those were, I think that was a helpful level of transparency from DOJ that, part of their concern is that there have been technological changes that make this guidance, perhaps not fit as well as at the time, and maybe some of the assumptions about how data could be used. In their view, some of those assumptions are no longer valid, or at least no longer valid in some situations. But no, I wouldn't be surprised. I think they're going to look at go back and look at what guidance is on the books, whether it's guidance that people are really using or not. If it's on the books, I think they're going to look and see whether they can possibly view it as a candidate for withdrawal. And I think one that I wouldn't be surprised at all to see changed on some level is the human resources guidance that I had mentioned before, if only just to clean things up and make clear that the healthcare statements that are referenced don't have meaning there either, because they are now withdrawn for all purposes. So so I could see them making that modification. I don't know that they would necessarily withdraw that guidance, given that labor is such a big focus for them. But they could tweak it. But I would say they have, I think, a clear hostility to clear hostility to safe harbors, because I believe that they, view them as limiting their prosecutorial options, and that even if in most situations the safe harbor really does capture things that are innocuous, I think they think that that antitrust is so fact specific that there could be situations where there is something missed. And so, and I just think they want to have a full range of options to be aggressive in ways that are consistent with their priorities, and not necessarily ways that they think their priorities may differ from prior administrations.
And I think you basically already told us what your answer is going to be to this question based on that description of, why the department did this and their priorities. But the emphasis, as you said earlier in the speech announcing withdrawal of the safe harbors, was on information exchange, and that's what we've been talking about today. But you mentioned in the very beginning of our discussion that the guidance covered other areas such as joint purchasing. So do you think this announcement signals a change of policy when it comes to those other areas in the guidelines that were covered, or do you think this is really all about information exchanges?
So I do think information exchanges were a key driver. That's my sense. But if it were just about information exchanges, they had other options. They could have modified the healthcare guidance so that it just took out the information sharing safe harbors, and they didn't do that. And so, or if they just thought that this was about the information exchange safe harbor not being modern, they could have updated it, just changed the criteria, but they didn't do that either. And so I really believe that this is, I think this is about, like I said, a level of hostility, or maybe hostility is too harsh a word. Maybe I should say a level of skepticism that safe harbors can really capture all of the possible iterations of anti-competitive conduct in a complex world. And so, in a complex world, going to Sergei's point, with a lot of technology and a lot of ways to do different things with data, and they've also referenced that the competitive landscape has changed, and you've got greater vertical integration among some players, and they don't necessarily think that was taken into account to the same degree previously when this guidance came out. Now, again, they could have, if they just wanted to have updated guidance, they could have had hearings. They could have solicited comments from stakeholders, and I think that would have, I think that would have been well received by the industry, because I think people would have felt there was still an opportunity to be able to make business decisions in a way that efficiently assesses risk. Again, even if the guideposts change, you at least know what the guideposts are. And right now, we're in a situation where they want to be so specific and not seemingly not have safe harbors at all, that it is, it's hard to identify the innocuous, low risk behavior that could let you, proceed in a really efficient way, even if, like I said, even if there are many, 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 many behaviors that are also innocuous, but now they carry a different level of risk. And part of it is we don't fully know yet quite where everything's going to shake out, because while Principal Deputy Mackey's speech was very helpful, it's a single speech, and without new guidelines, we are still dealing with a bit of a transparency vacuum. So I'm glad that if these are guidelines that they completely disagree with and they are not following, that they told the marketplace that, rather than people relying on them and then learning that, the hard way. And so that's transparency in a sense. But I think I would very much like to see more transparency from them, whether it's, additional speeches or workshops or what have you, if they don't want to do new guidelines.
Certainly would be helpful to have some guideposts to help assess risk. Well, this is very interesting stuff, and I think very important development for practitioners and in-house counsel to be aware of and to continue tracking. But now we're going to shift gears a little bit. We usually close out our episodes by giving our listeners a chance to learn more about the guest as a person. So Leslie, tell us something interesting about yourself that people who just know you professionally may not know.
Well, I am an amateur genealogist.
Okay.
And so,
can you describe what that entails?
Sure. I have researched my own family history, and I've researched it on my mother's side and my father's side. I've researched my husband's history. I've found out all sorts of interesting things and been able to share them, which has been very satisfying. And so my husband's family actually is applying to be on Who Do You Think You Are, Skip Gates' genealogy program. And that is inspired by research that I shared with them.
Wow, that's awesome. Okay, so now it's time for our final segment called The Curious Hat.
And now it's time for The Curious Hat!
And that music means that you get to choose a number between 1 and 10, and then we ask you a question corresponding to that number.
Oh my goodness. Okay, number 9.
Okay, if you could choose free front row tickets to any performing arts show or festival in the world, what would you choose?
Hands down, Beyonce.
Okay, you didn't have to think very long for that,
Nope.
for that one. Well, hard to argue with that choice. Thank you, everybody, for joining us for another episode of our Curious Amalgam. And I thank you for Leslie for doing it with us, and hope our listeners will tune in again next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.